Copyright law protects screenplays and even treatments, but what protects ideas? Hi, James Pacitti, entertainment attorney and production counsel in Los Angeles. In an earlier video, I discussed how a claim of idea theft can be the basis for a lawsuit under the theory of breach of implied in fact contract. But how can filmmakers and other creatives try and protect an idea without having to resort to litigation? And one method is, prior to a pitch or submission, a filmmaker can ask a production company to sign an NDA, or non-disclosure agreement. The non-disclosure agreement should have 5 key components. First, that the production company would agree that the filmmaker's idea is unique and valuable. That the idea is the filmmaker's proprietary information, that the production company will keep the idea confidential, and if it will not exploit the idea, and in the event that the idea is exploited, the filmmaker will be compensated. Now, whether a production company would agree in advance of a pitch or submission to enter into an NDA really depends on the relative stature of the filmmaker and the production company. Networks, studios, major production companies will never agree under almost any circumstance except for perhaps a filmmaker of great stature. So if a filmmaker cannot get a production company to agree to an NDA in advance, there are still a couple other alternatives. First, the filmmaker can try to get them to agree to an NDA in the midst of the pitch. After that, they've had some discussion that they can agree that now they've heard the idea, they can agree to this NDA based on the elements I discussed. And if that doesn't work, the last resort is that after the pitch meeting, the filmmaker can memorialize the discussion, what he pitched, and these other elements that I mentioned earlier in an email to those with whom he met. Therefore, there is a record of the meeting and the nature of the meeting. If you have any questions, or if you have a project you wish to discuss, don't hesitate to contact us.